Well, good morning, everybody. It's good to be back again. I think this is the first time I've done two lectures back to back, and they're connected, so I think it's going to make good sense. The formal is capacity, competence, and surrogate medical decision making in our specialty. Now, I'm going to note that what we're really talking about, first, disclosures. A retired nurse practitioner, no disclosures, a little bit about me, Sydney, Norway, Denmark, and Indianapolis this year. So, what we're going to talk about is how to talk about surrogate medical decision making in both hospice and palliative care. It's really what decision. We're going to differentiate capacity and competence, and we're going to talk about how to prepare an advance directive and why that is so important. Now, my elevator talk, if people would ask me, so what is it that you do? My elevator talk was I provide expert symptom management and facilitate patient-centered decision making in patients who have a really serious or a life-threatening illness. And one of the key components of that for me is patient-centered decision making. I am very interested in self-determination for myself, and so I have a tremendous respect for the wishes of the patient. We as providers have a huge responsibility to determine whether or not the patient is able to make a medical decision or whether surrogate decision making needs to be considered. And if so, who those surrogates are. Now let's take a look at common law. Common law states that people have the autonomy and the self-determination and the right to either accept or refuse medical treatment. Now, this gets complicated when you're not sure the patient is able to make a reasonable decision. Our legal system in the United States has a key principle that all persons are competent to make decisions about themselves, reasoned decisions, unless it's demonstrated otherwise. Now, in our country in 1990, huge legislation was passed called the Patient Self-Determination Act, and it had a lot of impacts on us, but pertinent to this conversation is that it incentivized via Medicare and Medicaid hospitals, skilled nursing facilities, hospices, and independent medical practices at the time of admission to that practice to provide patients their rights about making healthcare decisions, including the right to make an advance directive. And that meant that institutions had to tell people, you can healthcare decisions. You can refuse what we recommend in terms of medical or surgical treatment. You have the right to an advance directive, and you have the right to review the institution's policies about those rights. So, what does that mean for us when we're talking about decision-making capacity? It turns out not a whole lot because all that act really requires is that we ask, do you have an advance directive and do you want information about it? That often happens as a clerical action when they walk in the door, and it's often missed if they roll in the door. So having compliance with that act does not require us to make sure they have an advance directive at all, only to ask. So that piece of statute, that legislation really isn't that useful to us. Let's look at the definitions and then see where we are. So first of all, decision-making capacity is defined as the capability of a patient to make adequate medical decision making. In our context, capacity means they have to utilize information about an illness and the proposed treatment options and make a choice that fits or is congruent with their own preferences. Now, there are a huge number of myths about what capacity means. One of the first ones is that capacity, decision-making capacity, and competency are the same thing. And that is not accurate, although the terms are often interchanged, and I may make that mistake myself throughout our conversation. But we'll talk about competency specifically in a few minutes. Another myth about the patient's ability to make a decision is when they make decisions against medical advice that somehow is a lack of decision-making capacity, and that's not true at all. We also think that having the capacity to make a decision is all or nothing, and that's really not true and gets into a huge gray area for us. But a patient really has the capacity to decide if they have to go to the bathroom or not, much longer than they have the capacity to remember when they last went. We sometimes think that having cognitive impairments means they have zero decision-making capacity. That is also not true. We tend to think that if people have a lack of decision-making capacity, that's permanent, and that's not true. One of the most obvious positions is that if you're under anesthesia, you have zero capacity to make a decision about what happens. But medical decisions are made while patients are under anesthesia all the time. Once that anesthesia wears off, you're expected to have a full return to capacity. One of the other myths is that patients with psychiatric disorders, especially more severe disorders, have zero decision-making capacity. Not true. And the last is that psychiatrists and psychologists are the only people who can assess decision-making capacity. Also not true. We are all able to examine that question. Now, how is incapacity in decision-making present? And in this slide, which is a little bit old but hasn't changed, what you can see is that a meta-analysis, lots of studies, huge number of patients. The number of patients with capacity is listed, but the percent of patients with incompetence, if you look at Parkinson's disease in the middle of the slide, up to 42% of patients with Parkinson's disease, no surprise, will develop decision-making incapacity at some point in their disease process, especially late. Nursing home patients, 44% of patients lack capacity for decision making. Alzheimer's disease, looking at the whole scope of the disease, more than half. And people who are learning disabled, in terms of making medical decisions, that incapacity level or percentage may exceed 60%. Looking at it from just a little bit different perspective, kind of meaningful for me, being over the age of 57, is how many patients have limited decision-making capacity before death. This is also not a surprise, but I think the scope of it is under-realized. At a month out, up to 25% or more can really have limited or no decision-making capacity prior to their demise. But as that time towards end of life proceeds, as they become closer and closer to their death, within a week to hours before death, we're looking at two-thirds of patients with limited capacity, and at hours before death, three-quarters or more. Now, in that situation, which is especially common for us on the hospice side and in the hospital and the critical care and other sides, we have to recognize that a huge percentage of our patients, there's going to be a question about their capacity to make medical decisions, and we have a responsibility to make their wishes known and present. And frankly, the time to learn about wishes is way before this end-of-life moment. So the risk of lack of capacity, formally, somewhere between 40 and 70% of older adults in long-term care settings have some impairment of their capacity. Now, if we know that more than two-thirds of Americans die of 5 chronic diseases, heart disease, cancer, stroke, COPD, and diabetes, all of which are very commonly seen in all of our practices, and up to half of them have loss of capacity in the last 2 years, and up to 2 years prior to death, it can be a huge component of our practice where capacity needs to at least be considered. And then Alzheimer's disease is the sixth of those diseases, the sixth leading cause of death across all ages, and more than two-thirds of patients with Alzheimer's at some point will have loss of capacity, and nearly 100% at end of life. So when do we talk about capacity? So if we look at across the top, the likely benefit of an intervention versus the likely burden or risk, compared to on the vertical axis, when patients choose to accept the intervention or refuse the intervention, two of those situations have a high standard for capacity assessment. If the intervention that's being recommended has a high likelihood of benefit and is low risk, but the patient is refusing to do it, there's a high standard for capacity assessment. Now, in this position, certainly patients can make a decision against medical advice, but this is just a situation where your assessment of their capacity is highly tuned. In the same situation, if an intervention is likely to have a very poor outcome or has a very high risk, but the patient is insisting on it, I could say patient or family, again, a high standard for capacity of understanding this decision and being able to make that medical decision. On the other hand, or in contrast, if the intervention we're recommending has a low risk and a likely benefit and they want it, no one has a problem with that. We're going to proceed. If the risk is high for the intervention and the patient doesn't want it, again, because they agree with us, we tend to view that as a low capacity, but also everybody's in agreement that this is the best way to go. So just beware of those situations when there's a high standard for capacity assessment because we're a part of that and are a part of the responsibility to assess it appropriately. Now, different decisions have different thresholds of capacity required. Now, if a decision will prolong life and existence, and the capacity has not been assessed, but we're proceeding in a way that will prolong life and existence, save life and limb, Good Samaritan laws apply, in which there is very little risk to the healthcare provider. We are presumed to be acting in good faith, and there's a very low standard of risk or examination of medical decisions, even if capacity has not been established. But when a decision will likely lead to the end of life, the patient falls under vulnerable adult statutes. And there's a much higher threshold legally and ethically about the decision. And that is a huge percentage of our patients where we are talking about end of life issues. And the scrutiny of those is going to be much higher. We can stand on the prevailing standard of practice, including research evidence, the testimony of experts, and case law. And so there's a lot of really good material for us to stand on. I have no interest in having you feel like there are legal threats about coaching people through end of life decisions. That's not what this question is about, so much as to let you know that our decisions at that fork in the road have a little bit different kind of scrutiny and a little bit different kind of responsibility. Now, capacity itself has four parts. The patient has to be able to communicate a choice. They have to understand the risks, benefits, burdens, and alternatives of whatever's being recommended. They have to appreciate the gravity of the situation and have insight into the need for treatment. And they have to have a coherent thought process, which also means the ability to remember and manipulate relevant information. So if they're not remembering what you're telling them, you have a huge capacity question. If they're not remembering things that are going on, you want to be attentive to that. Please beware that many patients have to confabulate. I suspect because I am such a talker that I am going to be one of them. I have had the privilege of seeing confabulation happen in more than one family member, and sometimes the stories are spectacular and very believable unless you know what's really going on. So don't hesitate to check in with family and staff and others who have contact with the patient to find out if something, to verify that something is indeed accurate and really happened. So capacity in the state of Michigan is determined by two physicians. Now, non-physician providers are absolutely able to participate in the assessment of capacity and to document that, but the verification of lack of capacity requires two physicians to note it on a form, and each institution will have that form. And if you're in private practice, there is a standard state form. You can Google it. And that form requires, it's a one page, requires, we believe that John Doe no longer has capacity for medical decision making. Our assessment is based on their ability to communicate choices or understand or appreciate the implications or reason. And then two signatures. If someone who is a non-physician provider does the assessment, the physician provider indeed is required to go in and verify that assessment, but does not have to do the whole assessment. Neuropsych, if available, and psych can help, but they really approach capacity differently. And so it will be a much different kind of viewpoint. I will mention that if neuropsych is available, a cognitive assessment at that point is helpful. If only speech path is available for you to do cognitive assessments, that is also helpful, but not nearly as thorough as a neuropsych cognitive eval. So be sure if you have questions about that, just understand in your institution or institutions what the policies and procedures are about that and what your responsibilities are. Now, I do know that this slide is absolutely unreadable. The reference is my goal for you, but I wanted to let you know that there are tons of resources that give you questions for clinical assessment that talk about that in terms of that communication, understanding, appreciation, and reasoning aspect of it. And so I don't want you to feel like, okay, why didn't she give me all the questions? Because actually they're there, but I'm going to rely on other and expert resources to give you some standard approaches. And so this is a second resource about capacity assessment, and it again looks at that understanding and reasoning aspect and can be done in really a pretty succinct list of questions. And if you really likes assessment tools, there are a number of tools, particularly when used together, that are very useful, including one of the MMSEs, a MacArthur tool, a capacity tool, and the Hopemont capacity assessment. These are readily available. I chose assessment tools for you that are available free of charge or open domain. And so you have a lot of resources in terms of really being precise about your capacity assessment. And check if you're working in an institution that has a case management or social work department, they may have a chosen tool of assessment, capacity assessment, as well as your speech path department. And it makes good sense to work in collaboration with them and use the same materials. Now, I am not addressing pediatric capacity assessment because that is a whole lecture that you're going to get to have at some point in your session in the fellowship. But has interesting questions about whether a decision will prolong life or existence or likely lead to end of life. The status of parental decision making in that situation becomes very dicey at times, and whether or not the child participates, particularly in consent, another teaser I'm going to give you to say this is a whole topic related, but it is really an area all of its own. So, what's competence then? And how is it different from capacity? So, decision-making competence is a legal term. And in United States law, it talks about the mental capacity of people to participate in either legal proceedings or transactions and the condition mentally that they must have to be responsible for those actions. This determination of competence versus incompetence is a court-based judicial decision. After determining that an individual cannot make prudent decisions in their own best interest, the court will assign a guardian to make decisions on the person's behalf. And if the situation is urgent, they may determine a temporary guardian. Now, please know the guardian ad litem is the person the judge has requested to help determine if there's competence by view of medical records and talking with the patient and those around them. And so they typically cannot make decisions unless they talk to the judge. A petition for guardianship will vary in each county, and petitions for guardianship can be undertaken in either the county the person resides in or the county the person is currently in, which may not be the same. And this decision, this attribution of competence is decision specific. So, just a word about guardianship and conservatorship. What I'm really recommending is that you read the papers. They're usually a maximum of 4 pages long with a lot of space in between. And the things you want to look for Is the paperwork signed indeed by a judge? And what's the date on that? In the past, those papers have had expiration dates. That's not always the case now. And so you need to look and see if there's an expiration date because if someone produces documentation, but it's an older school documentation that has expired, it's interesting to advise you, but it's not legally binding. And so you need to look at those dates, and it's probably good to document that, even if the document itself is on the chart in your notes that you've reviewed the guardianship paper, that it's current, that it's witnessed, and who is designated as the guardian. Conservatorships do not address medical decision making, generally speaking. They're usually of a minor or about finances. They're often temporary. So if you have conservatorship papers, which patients or families or others have produced to indicate that they're in charge of the patient's decisions, they are not medically binding whatsoever. So you need to know what paperwork you have. There have been several different types of guardianship papers, and not all of the judges in every county are fully up to date. Some judges still do some old school guardianship paperwork, even though there have been new statutes in the last 10 years to update those and give more ability. Up until about a decade ago, many guardians did not have the right to make end-of-life decisions or code status decisions about patients. That is no longer true, but you still really have to look at your paperwork to see what decisions your guardian is able to participate in. So if the patient lacks capacity or is incompetent for their medical decisions, who decides? Well, obviously, either a surrogate has been identified, either through a durable power of attorney paperwork or an advance directive, or a guardian through court action. So some kind of surrogate has been identified, or you don't have one, which happens quite a lot for us. And I know that. We'll talk about both. So how do you find out if a surrogate has been identified? You're looking for advance directives or medical durable power of attorney paperwork or a guardianship determination. You're going to be asking patient and family and looking for paperwork. Now, a lot of times that paperwork's not there, and so you don't know, is it present and just missing, or is it not been developed at all? And a lot of times people will tell you, but they may not remember for sure because a lot of people don't know what exactly they executed, and often they don't know where the documents are either. And so I share this with you because we're going to talk about at what point in your relationship with a patient do you start to talk about getting this paperwork in order? And if your practice is strictly high acuity hospital stuff where people are coming in medical crisis, you don't have very much time in your relationship with them to discuss getting this paperwork in line. But if you have an ambulatory practice or you're affiliated with an ambulatory practice, and if you have a full spectrum, full continuum kind of practice, it really makes sense to have the standard for your practice to have these questions be part of your evaluation, not just symptoms, right at the beginning of your contact with patients. So let's talk a little bit about advance directives. So an advance directive is a legal document that has state by state statutory or legislated requirements. So each state has a requirement about what the components of an advance directive need to be. So in all the states in the United States, these may be prepared with an attorney or without an attorney. So consequently, there are statutory advance directives, which means your organization has developed a document that has all the state required components. And if it's filled out correctly and witnessed correctly, you don't need a lawyer to make it legal. It designates a patient advocate who can make medical decisions if the patient lacks capacity. It may even include some wishes about some broad types of medical decisions, like code status or funeral preferences or even life support. It can be done with an attorney as well. When an attorney participates, it's usually part of a larger legal set of documents and may actually be harder to read. So who should have an advance directive? So that Self-Determination Act in 1991 only requires us to ask whether they have one or not. And although there's no legal standard about when to start recommending advance directive to patients. There's a loose recommendation that by the age of 50, it's discussed with most people. So if we were in a live class, I'd ask you to raise your hand. How many of you have an advance directive? I do. Early on in the times of having this conversation, it was primarily with fellows, and often there were only two of us at the table, maybe three, who had an advance directive prepared. And I'm just going to share a small anecdote about that. So I am over the age of 50, and so I do have an advance directive in place. It actually is harder to put together than you might think. My oldest daughter, full adult, probably older than many of you at the table, um, wasn't sure she could honor my wishes. And so it took some time for us to work through because she felt some responsibility as an older daughter to take that on, but she was really not sure she could pass up medical opportunities for me that I might not want, but that she thought might prolong my life. So we had to kind of negotiate one of my middle children to be that medical director for me, that patient advocate. For those of you who are under the age of 50, I'm just going to point out that for those of us over the age of 50, if we have a catastrophic event in the next 12 months, versus if those of you who are under 40 have a catastrophic event in the next 12 months, which of us is more likely to need a patient advocate? And the truth is, statistically, although those of us who are over age 50 are more likely to have a catastrophic event, our catastrophic events are more likely to include preserved mental function. Whereas if you're under the age of 40 and have a catastrophic event, your catastrophic event is most likely to include lack of capacity. So I'm going to make a strong point that I encourage you to recommend to all adults that they really think about having and choosing someone to make their medical decisions, because the what if you don't becomes very interesting. First, we're going to talk about approaching your patients about preparing an advance directive. And so, some easy sentences you can use. Have you ever prepared special paperwork to designate who would make a medical decision for you if you were too sick or too sleepy to do so? Or the state of Michigan thinks this is so important that they require us to ask you about it when you see us. Did you know that in Michigan, your spouse does not automatically speak for you if you don't have this paperwork? Did you know that in the state of Michigan, we can't even talk to your domestic partner unless you have this paperwork? Unlike some other states, but in Michigan, domestic partners have no standing. Or can I give you a sample advance directive and show it to you? And although I didn't put it on the slide, if you have a team for which your social worker or someone else on your staff is designated to do that conversation, to introduce that and offer that to your patients early on in the situation. They may ask, you think something's going to go wrong? Why are you asking me this? And really rely on saying, this is something we want to do so that we always honor your wishes and know what you have in mind. And we want to do that while you are in charge of your care so that you remain in charge of your care even if you can't talk to us. A couple of key points. The patient has to name the surrogate decision maker. If the patient clearly lacks capacity and they're a family at the bedside, please do not hand them an advance directive form and ask the family to fill it out because they may not do that. I do recommend that at least one backup surrogate be identified, the patient advocate and the backup patient advocate. And I do this because I can't tell you how many times the patient's advanced directive is in place, but they have only one surrogate named, and that surrogate is their spouse who is in the same car accident as them and is currently in surgery and unable to participate in decision making. In our state, two witnesses to the patient's signature are required, and these cannot be the named surrogate, should not be immediate family members, and cannot be healthcare providers. And so if people ask you about signing advance directives in the state of Michigan, we are not to provide witness in a professional setting to advance directives. The risk of coercive action there is the reason. You are, however, able to participate in private domain witnessing of advance directives. just not in your professional capacity. There's also an acceptance by the surrogate required, but this can be done later, and it can be done on the phone with witnesses and addended to the form. And sometimes patients don't complete the form because they're waiting for the son in California to come home at Christmas, and you do not have to do that. That aspect can be completed later. Please, please, please have the patients keep the original and provide copies for their chart, and encourage them to please provide a copy to their surrogate. I also can't tell you how many times I believe that a certain family member is a surrogate, but that advance directive is locked up in the patient's safe and nobody can get to it, which might lead to a whole interesting cocktail hour conversation about how does one prepare one's family members if something should happen to you suddenly in terms of your financial situation. And having recently witnessed kind of a hot mess in that regard, that has been encouraging for me to straighten things up on my in my own backyard. So let's talk about medical durable power of attorney paperwork. It does the same thing as patient advocate paperwork. It has to specify the surrogate decision maker or patient advocate. Please, it's prepared by an attorney. Please know that there are two kinds of durable power of attorney. There's general or financial durable power of attorney, which generally does not cover medical, other than saying that the designated advocate may review the medical records. So if you have what appears to be a general durable power of attorney, you have to read that whole thing, because if the attorney did not put in a specific article or paragraph about medical decision making, a general or financial durable power of attorney does not include medical decision making. Many patients and family members believe that the executor of a will is the medical power of attorney also, but that is not true. The executor of a will makes all the decisions after the patient is dead, but nothing before. Of course, it's possible that a patient advocate or medical power will be determined and they will also be the patient's executor, but that is not automatic, and they each need their own paperwork. Medical durable power of attorney may also specify patient wishes and preferences, but they are often very boilerplate, kind of reactive to the tube feeding withdrawal of treatment cases that we experienced in the 70s and 80s. And so they are not that useful. They might say something like, if two doctors have determined that I have no chance of recovery. And so they're not useful at all, particularly in an acute situation. Please know that patients may bring documents from other states, and the statutory requirements of other states are meet the Michigan standards. The Michigan standards do not meet the standards in every other state, but the standards of every other state meet the Michigan statutory standards for. However, some states do permit living wills, and living wills are not binding in Michigan, but they are advisory because they often have much more specific patient wishes. If the patient is financially secure or well off, they will most likely have a living trust, which is a financial document. And that particular financial set of documents needs to include not only the trust in which they put their assets, but also it must include a last will and testament and a medical durable power of attorney. And so if they have they may not remember if they have an advance directive or a medical power of attorney, but you say, do you have a financial trust? And if they say yes, that document is in their trust documents, and they usually know where that is. People pay a little bit more attention to their financial documents than their medical documents often, not for clear reasons. So these are a couple of samples of the my local stuff. So the Five Wishes is a general nationwide kind of advanced directive booklet that's very easy to work through. It actually has multiple languages and a pediatric version, and is available easily online. You see that I pulled down the Trinity Health version, the Michigan Metro version, the Corewell Health versions. They look different, but they all have the same basic components. And so if you have an organization that you work with, one of these documents is a good example of how you might use it. Just figure out what example your organization is using and become familiar with it so you just know what's in it. So I want to talk briefly about my post, which are Michigan Physician Orders for Scope of Treatment. This is a nationwide movement to have a portable order for end-of-life treatment that can be moved between a patient or follow a patient between institutions. So if they move from the hospital to the nursing home, things like a no-code order can follow them. And I highly encourage these. In the state of Michigan, there are a couple of limitations that have made these not as useful as we might have hoped. First of all, they have to be re-signed by the primary doctor and the patient annually, redone annually. And a lot of patients, especially as they move towards end of life, or if they don't, are not necessarily getting those annual doctor's appointment just to get this form done. This document has the sample orders that you can see about CPR and other kinds of levels of treatment, which is very useful, but they do not include the surrogate decision maker designation. So this does not replace an advance directive because they do not in Michigan specify who the patient advocate is or the surrogate medical decision maker. This is prepared by the patient and provider in Michigan, does not need witnesses, although some institutions will kind of buff their own form that looks just like this, which is the state form taken right off the website. But they will add a witness section, which makes zero sense. And many facilities require their own forms for DNR orders. Now, one of the other interesting kind of technically unworked through place, or a few of them, are patients don't know where to keep this. And we know where to keep them on the charts, but we aren't always good about this. And often the patient will give you the actual document and they don't necessarily get returned to the patient, so then they're lost. So, technically speaking, by statute in Michigan, if a document like this is executed in a doctor's office with a patient, they should be able to produce it at the hospital and get an automatic DNR order. But I promise you that does not happen. And there are lots of reasons for it. They're mostly policy based, where the policy is in opposition to a Michigan statute. Not only that, but if the patient is transferred from the hospital with this DNR order in place, for example, to a nursing home or a rehab facility, it creates big issues because with Medicare, many rehab facilities will not rehab a patient with a DNR order in place, even if it makes perfect sense. They just have an internal policy that doesn't fit with that. They'll only rehab patients who have full code, kind of like patients who have a DNR order have to revoke it often to get a needed surgery, even if it's a very mild or moderate surgery. So this is highly frustrating to patients and highly frustrating to staff. I have been going round and around with my 90-year-old mother's independent living facility. So she lives in a continuum facility. She's 90 years old, independent, lives in an apartment. And we had the conversation about 2 years ago now about, if your heart stops or if your breathing stops and the people call 911, do you want them to attempt to put that breathing tube in or to do CPR? We had an honest conversation about the statistical likelihood of effect, which is nearly zero in a 90-year-old with osteoporosis. And she said, or would you like a natural passing? And the words natural passing or a natural death or a peaceful death, that made sense to her. She's really kind of ready for that. And the whole concept of spending weeks to months tied up under all the medical paraphernalia did not appeal to her at all. And so we executed the state of Michigan, Kent County. The county of Kent is the county in which we reside, and the Ottawa County, which is where she resides, do not resuscitate order, which is different than this. So EMTs cannot in every county honor the MyPost yet. So again, many of the counties have not caught up in the state of Michigan with the MyPost statutory stuff. I'm sharing this with you so that you kind of know that it's very murky here when you try to do orders. So we executed the form with her doctor. She's got a nice Ottawa, Kent, Michigan do not resuscitate form to put there. And she went to bring a copy to her facility and they said, no, that doesn't work here. You have to use our form. So we had to go back to the primary doctor with the form, get the facility's form signed, even though all of us knew that did not legally need to be done. But her staff could not follow that do not resuscitate order until it was on the letterhead of the organization. It was also interesting because the organization required witness signatures, which the statute in Michigan does not require for DNR order. So it's very murky, I'm here to tell you. And now you know a little bit more while I'm passionately interested in having these conversations while everybody's awake. As a sidebar, just to let you know, my mom carries this document around in her rollator, her walker, rolling walker. And when she goes to play cards, she shares it and tells people she's quite pleased that we finally accomplished this all with all the hoops we had to jump through. And apparently, she plays cards 4 nights a week. And apparently, there are several groups of people in her peer group who are also interested in developing their own DNR orders. But she was quite tickled about it because three of the women, particularly, were not interested for themselves, but they were interested for their husbands. So I don't know what to make of that, but we thought it was quite hilarious. So now let's go on to no surrogate is identified. So surrogate succession is a state by state thing. So you can see here, I've got Maine, I've got Maryland, I've got Michigan, and I highlighted Michigan, which says some member of the immediate family or next of kin or guardian, but not specified, and the priority is not specified. So there's very little useful information here other than some kind of family relationship. If you look at Maine, it talks about the spouse, unless they're legally separated, an adult and a spouse-like relationship. So this talks about domestic partners. So in Maine, if you have a domestic partner, they are second after for decision making, and then adult children, and then parents, etc. If we move up to other states, it will be spouse, but no mention of domestic partners. So it's different in every single state. Again, in Maryland, spouse or domestic partner, quite a recent cultural modification of statutes like this. But please know, if you went to medical school and learned what the succession rules are for decision making in the state that you went to medical school, and that state was not Michigan, the rules are different here and they're not very helpful. And so often I've experienced that in organizations, the attorneys who are developing the policies learned succession in the state that they went to law school and don't realize it is a state by state statutory or legislative determination. And so you have to know wherever you are practicing what the rules are for succession. And in Michigan, it's a free for all. So there is a Michigan default for surrogate consent, but no succession statute. The priority of surrogates, if you don't have paperwork, like an advance directive or a medical power of attorney, is not specified. So no succession akin in Michigan. So it's not spouse first, and spouses cannot make decisions if there's no paperwork. Most people are tremendously surprised by this. So if you know that your spouse or your domestic partner knows your wishes, but you haven't done paperwork, they aren't going to get to decide. Patients cannot verbally name a surrogate. They do not have a standard for any kind of decision making, and there's no judicial recourse if the surrogates disagree, the whole cluster of kin. So there is some applicable Michigan case law, not statutory legislated law, but case law that is currently the standard. And that is consensus by first degree relatives. First degree relatives in Michigan include your spouse, but not domestic partners. Domestic partners currently do not have legal status. There is no common law marriage in Michigan. There is no common law marriage in Michigan. In fact, there are only 3 states that still have common law because domestic partnership is so common. Spouse, adult children, siblings, and parents. So I want on your hands for you to figure out how many people this is. So I have a spouse, I have 3 adult children, I have 3 siblings, and I have a living parent. So my committee by consensus is 8 people. My husband has 6 siblings. Count on your own hand who your consensus committee might be. And you realize, okay, doing advanced directive paperwork might make sense, particularly if you have a sibling or a parent who you do not think would honor your wishes or know your wishes. In Michigan, besides consensus by the first degree relative committee, people who are by proximity presumed to know the patient's wishes may be included. There's no guideline for doing this, but If you have an elderly person brought in by a neighbor who has been caring for them, and that neighbor talks to you about what their spoken wishes were, they may be involved in the decision making even while you are trying to determine if there are any first degree relatives anywhere around. Please know that the usual standard of care applies. If by to preserve life or limb, a medical decision is indicated and there's no decision maker present, the usual standard of care is to provide that care. That can be provided. In Michigan, there is no waiting period. There are a couple of states, primarily in the South, in which if an individual is not brain dead, has brain activity, but there is some question about whether they want to continue therapy in their current low level cognitive state. The decision to withdraw therapy, there may be a waiting period, usually a week, before therapy is withdrawn, but that does not apply in any situations in Michigan. There is no waiting period in Michigan, but beware, other states may be different. So, how do you tell who should make the decision? You can ask the patient, even if they're not completely full of capacity, if they're able to participate in conversation, they can tell you who they think it should be. Ask the visitors, although expect some creative responses. Check the records and beware of inconsistencies, particularly around the aspect of wife versus domestic partners. It's really important in Michigan, and sometimes it's a little tricky to identify that. And it's okay to say, you know what, I really want to preserve Bob's wishes in the whole situation and follow the protective statutes in Michigan at the same time. So, you're Jane. Tell me how you're connected with Bob. It also will help you uncover people at the bedside who might be loyal friends or pastors or chaplains, and you can avoid some real accidents about that. I have noted a lot of inconsistencies in charting about whether people are wives, daughters, sisters, or spouses or domestic partners. And frequently, long-term domestic partners will tell you they're the spouse so that they can maintain contact. So you have to be a little careful about that. You can call the family to ask. Please document what you found, who was at the bedside, and make sure everybody knows it has the same terminology for them. In Michigan, if there's no identified surrogate and the patient does not have capacity in your determination, decisions are made by family consensus effort for family members not present. Sometimes you really cannot get a hold of the estranged person. Just document 3 attempts and that there was no response or how they responded, that they don't want to participate, and that is acceptable. You can make a guardianship petition that may be indicated. It can take several weeks, and so it may not be helpful. Providers can make a decision, has to be physician providers, about medical appropriateness. You may want to get ethics input just to be supportive. And your institution, legal department can establish some policy, but there's really unclear standing about that. Be sure to bring in the patient's voice. If you have a surrogate decision maker, often this is something they really never considered having to do, particularly if includes end-of-life decision making. And so bringing in the patient's voice, either by written documents or your conversation with them or asking them what the patient would have said, can be a tremendous relief. The patient's voice may be present in their memories or in other family members' memories or in yours, in the record, in previous conversations you or others have had with the patient, and in their advance directive documents. But I think that's our final self-determination responsibility. And I think if you approach this in the mind of how you would want decision making to occur for you if you were too sick or sleepy to make a medical decision, I think you'll have the level of respect and thoughtfulness that will help these decisions be really effective and appropriate for our patients. There are a bunch of references on the end of the slides, which I'll provide after the lecture. And I'm going to stop the share, but we have a few minutes for questions.
Excellent, Barb, as always. Again, I mentioned this last week, but I just learned so much every time I hear it, even though I heard it before. And I just wanted to emphasize one of the things you mentioned about a third of the way through in terms of the fact that it is the young folks that are much more likely to have need of capacity decision making. And even though they don't necessarily recommend or push advanced directives until after the age of 50. And we think about the notoriety of the ethics cases that hit the press, you know, your Terry Shivos and your Karen Ann Quinlans, all young people who didn't have that. And there was much conflict amongst family members. So in this particular circumstance, it doesn't matter if you got a committee of first degree relatives because they disagree.
Mhm.
And those cases went to court and nobody's happy with the decisions. And so I think it's really, really critical that that if you do nothing else as a young person, identify someone who you want to make those decisions for you and have conversations with them. That just saves an awful lot of heartache in those very, very difficult and already heartaching circumstances where they may need to have that happen. The other comment it just struck me, and we've always understood the legalities of who can make decisions and how are decisions made. But my suspicion is that everybody on the call here has had circumstance in which they've been in the hospital, decisions have had to be made. Someone by the bedside says they're a spouse or whoever, and they need a consent form, and they kind of whip in, and whoever's sitting at the bedside signs a consent. And no one ever really checks to make sure, was that a legitimate legal decision maker? And the vast majority of time it flies because it probably was the appropriate thing to do, and it was probably the right thing to do, and there's really not going to be dissent. But I can tell you, having served on ethics committees for many, many, many years, the ones that come to us are things exactly like that. When they weren't careful and there was someone else hanging in the wind, or something went wrong. And when something goes wrong, now you've got people coming out of the woodwork saying, well, wait a minute, that person should not have done that. So taking that extra moment to make sure that you have the documentation, and if you don't, to identify the steps that Barb outlined in terms of how you secure adequate decision-making property. And also, and appreciate you referencing the best interest standard, that we as physicians have the capacity when the patient doesn't have the capacity, and there is no surrogate decision maker, to provide standard of care treatment for patients. Mm-hmm. And so there's a number of ways that can be done. But anyway, I appreciate those and just wanted to emphasize those things. Stephen, you got your hand up. What's on your mind?
Hi, sorry. Yeah, I've just been texting back and forth with a contact of mine here. I was aware that there was a bill presented to the Michigan legislature to try to clear this whole issue up of us being an outlier, of
Yep.
being very nondescript. And I was just texting back and forth with him. I guess it's been introduced. He doesn't expect it to go forward this legislative session, but maybe next one. I think a lot of us has been hopeful for a few years now that Michigan might clear up their surrogacy mess. So I guess the update is not this legislative session, but maybe soon we can expect better clarity. Here's hoping.
And I appreciate that because it's been introduced repeatedly over the last 15 years. I am cynical now, but again, like you, here's hoping. It certainly makes sense. And certainly there are a lot of states coming into compliance. The current political environment actually is not encouraging for that to have clarity. And it's at high risk of landing in the same pile that the My Post did, which is a great idea, but not quite effective to use. I hope you're right, Stephen. I hope you're right.
Well, I agree, and I share your cynicism, Barb, and from my perspective, and this is about as political as you'll ever hear me in a public forum, I just wish that people on both sides of the aisle would recognize that people on the other side have good ideas now and then. And the dissension that occurs has nothing to do with the rationality of the law or the need to correct this. It has to do that they have an R or a D. And so if I'm a D, I can't accept something that an R advances. And it's just really, really sad that our political state has gotten to that point where we just can't honor, respect, and like people that may have different political views. But on the central issue for which there really should be no political dissension, still it gets caught up in the politics of that little letter after the end of the name. So I actually, although I do understand the cynicism, I share Stephen's naive optimism that maybe something will happen this next legislative session.
I hope you're right. I'm going to point out in the chat, Elena noted that the MMSE technically requires a licensing fee. Most organizations have paid that so that it can be used internally. And then MME, which was a precursor, actually is available in public domain. So she is correct about that.
Thanks, Elena. Other questions and comments?
Does an advance directive surrogate's decision on resuscitation always override a pre-prepared DNR order if they're in conflict, like the MI post?
What a great question.
What a great question. So the answer in part is not going to be satisfying. So the MMI post, because it's relatively new and does not have a great policy standing in most organizations, is often not well recognized or well used. And in that situation, it could go either way, influenced to a great degree by what the medical recommendations are. Does that make sense? So the answer is no. The surrogate does not always get to override a patient's decision, and the most common thing would be the patient wants a DNR and then has lack of capacity, and then surrogate steps in and says we want everything, right? We've seen that happen, and so that will have to walk a very dicey path. One of the questions of which is, are you required to offer full code services to a patient for whom that is not medically indicated? And so that's a policy question internal to your institution and goes to that long-standing question about why is full CPR our default standard? So your good question leads to a lot of other questions. And if that's a concern, or once you experience it, addressing why full code is the default standard becomes the bigger question, I think. I hope that's a little bit helpful.
The default is actually predicated on something that you had commented on earlier, Barb, and that is that if in the absence of any particular directive, the efforts to save life, limb, extend life is the default. And that's why CPR is sort of considered that as nonsensical as it seems at some particular point in time. To your point specifically, David, what I found in ethics work is those are the things that really are helpful to get to an ethics committee. Because Barb's right. The most often thing is that medically it doesn't seem to make sense to do CPR. The patient has that as part of their directive, but you've got a surrogate who says, I want to override that. In most circumstances, I know when they came to our committee, we would certainly side with the medical rationale as well as the patient's directive and say that a DNR is appropriate in that particular circumstance.
John?
Yeah.
Fred Van Alstyne. So I have some degree of expertise on the MyPost thing since I've been involved with it forever. The MyPost is not binding in the acute care setting. It's an outpatient preference and is primarily binding on EMS personnel.
Right.
So, and then every time you change locale from outpatient to inpatient, it has to be reaffirmed. That's part of the problem with people transferring from the hospital setting where it might be completed out and vice versa. So basically it's binding outpatient. It is not binding in any acute care hospital setting. It still is a clear statement of preference and should be respected in that sense, but it's not legally binding in the acute care setting.
And I think that underscores the challenges that have kept it hung up is because there are some limitations in terms of that. But and Barb used this term also, documents like that can be advisory. You mentioned the living will also is another sort of a thing. And I think we need to respect those sorts of things. If someone has made I've seen families, present text messages that they've had back and forth with family members. And within the context of that conversation, it's really clear what that patient really intends. And even though that may not be legally binding, I do believe that it is, it's reasonable to consider that as we go through the decision-making
Yeah,
process.
I think at the end of the day, we're all in agreement on that, which it's about respecting patients' wishes.
Michael, you got your face up on screen. Good to see you.
Yeah,
I
hi.
see. Go
I
ahead,
got
Mike. I see your question. Go
a-
ahead.
I got actually two questions. One is I've had NPs ask me can they weigh in on capacity assessment? And the other question has to do with guardians. Because I know that in certain counties, it's a lot harder for a guardian to change somebody to a no code than in other counties. So can you comment on that?
Sure. For the first question, so nurse practitioners and PAs and other health providers, bedside nursing staff, if you have them, social workers, certainly can document a capacity assessment. They can do a capacity assessment, but the determination itself in the state of Michigan has to be done by two physicians.
Okay.
The exception of that is neuropsych can do a full cognitive evaluation and say that based on this cognitive evaluation, the patient lacks capacity. But neuropsych specialists are the only ones in the outpatient setting who can do that, and they even will not do it in the inpatient setting. They'll do it as a recommendation to be one of the signatories. And then repeat the second question for me.
So with guardians,
Yeah.
we run into this
Counties.
sometimes where guardians have a hard time changing to DNR. Some, like Hillsdale County, I believe, requires a court hearing, and it can be a phone testimony from the physician in the hospital saying, yeah, this is what this patient has, this is their prognosis, this is our medical recommendation against CPR and why. And then they'll say, okay, the guardian can change to a DNR. Other counties, it's not a problem. The guardian exercises judgment and makes the decision. So can you comment about the role of the guardian in changing code status?
In the role of guardian changing code status, by statute, guardians may now be adjudicated to have durable power to change code status. And most new guardianship documentation in big city counties will include that, even for people who have capacity for developmental disability. But in the rural counties, it's unclear to me why. My attorney sources have told me it really reflects judges who have just not caught up to the statutory updates and remain very old school in their procedures and have just not updated their procedures. Because by statute, the judge may grant that power, and it's been recommended that they do, but often they have not, and they do not update the forms. They really keep that their responsibility in that regard, take it very seriously to protect people, and have not updated to the statutory permissions.
Rob, you undoubtedly have to face this sort of situation just about every day of your practice.
True, right. No, great talk. Appreciate it. I'm always learning too, as John mentioned on this talk. So just one quick, that was a great question by Mike too, and who can do the activation. And I believe the fellows cannot either. It has to be an attending physician. Is that true? I think we talked about that before.
So technically a licensed physician, two licensed physicians can do that. So technically the fellows can do that signature, but you have to check your organizational policies about it, because frequently organizational policies will not permit a physician in any kind of learning status to uncontracted status to make that decision or sign those documents, because they're not technically full out employees of the organization.
Okay.
John, I also have one other observation or factually statement. There are two sets of statutes that apply. One is under the mental health code, and one is just the general statutes. People who have lack of competence or have a guardian appointed under the mental health code are usually people who have learning disabilities or who have never had capacity for decision making. Those people have special protections, and those guardianship papers have to specifically designate whether or not the guardian has the authority to make code status decisions. They have to do with protecting the vulnerable, as opposed to people who have lost their capacity and had a guardian appointed and had it at one point, which is another whole set of laws. So there's actually two different statutes that apply. One's far more restrictive.
Thanks. And just actually as a transition to that, stay tuned, because next week we get to hear a little more complex aspects of this as we talk about pediatric decision making. And so that'll be great. We are past time. Barb, thanks again for just a great talk. This will be available later today on the YouTube channel for those that want to revisit it. And we'll have access to the slides in that link as well. So thanks again, Barb. And for those that are going to stay on, you can stick around and we'll transition to our case presentation.
Thanks all. It was a privilege. Take care.
Bye-bye.